Oh, little kitty, kitty, kitty. Oh, little kitty, kitty, kitty. Hello and welcome to Trial TV Live. I am the Squeegee of Justice coming to you from a different angle. This is where I normally sit, right here. And this is a new angle. So we're hoping that this will work. We're going to do a dual stream. Let me just check the audio here. How's the audio, guys? Coming to you from a different angle. All right. This is where I normally sit, right here. You guys can hear me okay? You can see me okay? Everything looks cool? All right, so thank you for joining us for day 42 of California versus Monica Sementilli. We just went through rebuttal of the state. We've had closing arguments. We're going to hear jury instructions next, and then the case will go to the jury. So thank you so much for joining us. Appreciate you guys coming on in. The reason I'm over here is this is going to be dedicated to Monica Verdict Watch. And then when Lori Daybell kicks in at 2 o'clock, we're going to be over here following that. So, where's Super Ball? She's right here. I can't. The camera is connected to the computer, but she's literally like, you see my finger? That's where she is. Maybe I can get a little tail. I guess I could tip it down a little. Let's see. Can we get Super Ball in here? Yeah, she's. Let's see. Yep. She's, yep. Hi. Well, hi. She's literally like right here. Little kitty. So, and she's biting my arm. Yeah, I can't tip it down anymore. So anyway, thank you guys for joining us. Appreciate it. Let's see. Who is, yeah, she is in her safe spot. She's absolutely in her safe spot. Yes. All right, who is with us? Billy Moore saying guilty. Shirley Roth, Widespread Panic, Dreama, Only Fan, Queen Olive Ruth Ann, and I'm getting bit. Fala, Sinbad 33, G Stewie, hey Mona, Carol, thank you for joining us. Baka, thank you for flying Sun Country, nice. Therapist you know. Is anyone in here more interested in this verdict watch than Lori Daybell? Well, guess what? You don't have to worry about that. We got you covered. We have got you covered. We're gonna stream both. MG. Oh. All right, let me get over here. Nope. Hold on. Verdict watch. This one. Nope. All right, I'm on a different computer, guys, so just bear with me. Okay. Hey, Alice, thank you for joining us. JM, how long do you think the jury is going to take? We'll do a poll. Hey, Maddie's mom. Irish Amy, can't believe we made it to this point at last. MG blows kisses and sends winks to Baker DeMonica, right? Ken and Widespread dropping some Super Ball emojis. Too late. Gordon, see my finger? At least I didn't say pull my finger. Hey, benchmarked by Alessi. Justice for Fabio. Nice. You Missy, you love this. Looks very studious. How much money did Monica get? She got nothing. She stands to get like 1.6, I think. Capri Law, it's a whole new vibe. The main thing is, the main thing is that we're going to be streaming. We're going to be dual streaming starting at 2. So we're figuring, okay, judge is going to give jury instructions from noon if they start on time, noon until maybe 1 hour for jury instructions, and then it's going to go to the jury. We're hoping within 2 hours. So I'm just hoping that they don't take. Listen to me. I'm hoping they don't take too long. I mean, a woman's life is hanging in the balance, of course, but I'm hoping for a quick verdict one way or the other. That's all I can say. Hey, Hellcat, hello to you. And to our mods, thank you for, we're splitting a stream. We did this before. Like last year, we did this quite a lot, actually. Sarah Boone, we were dual streaming during Sarah Boone. We have done this before. It was before that I came on camera. We did one time. We did a dual stream when I was on camera. So we have done this before, and yeah, this is a new one for most of our mods. Therapist, and Zoo, you guys know the dual stream. You are familiar with the dual stream. But to all our new mods, thank you for hanging with us and bearing with us. I know it might be a little challenging to be on both streams, but chat, just be kind to our mods when we do kick in with Lori at 2 o'clock. So just be aware that our mods will be spread thin. But if we're in verdict watch here, we can all be focusing on Lori and just kind of keep an eyeball here, and then when the verdict comes in, we can all jump over here. That's kind of the plan. Surely we can always break when the verdict comes in. Well, we'll see. We're gonna see. We're gonna stream. We're gonna do what we can do. Yes, Ken, we'll make it work. Irish Amy, we will definitely be kind to mods. They rock. Yes, they do. Hi, Helen. How are you? Thank you for joining us. Hellcat, we got you, Ken. Don't worry. Follow, yeah, don't make me use the timeout button for real. Therapist, we got this. There's some mod love from Baca. Shirley Roth, thank you, mods. Ken, I believe. Capri Law, let's do this. Yep. We're not going to let this get in our way. All right, I need to pull up my description here. All right, so here we go. Judge Cohen is going to be doing jury instructions. So day 42, jury instructions. And he did say he will see us at 9 o'clock. So here we are, 9 o'clock. Well, yeah, 9 o'clock Pacific Coast. JM, mods are great. Yes, yes, they are. Sinbad, whoop, made it in time. Capri Law, I love our chat. Carol says mods rock. Hey, MEG, thank you for joining us. Appreciate it. Helen, can't believe we're here at verdict time. Finally, I know, 42 days later. Ken, chat never does anything wrong anyway. That's true. Chat never goes sideways, right? Shirley Roth, go run and get some cat food. Sounds good. Hey, Miley, we might get a verdict today. I'm hoping. I am hoping for a verdict. I'm absolutely hoping for a verdict. Bammy, here we go. Yep, here we go. And for those coming in new, I am at an old computer. This was my old computer, and the other computer is over here. So this is a different different camera, different microphone. Hellcat, you guys rock. Chat. 40 days, 42. I think it's 40 days. 40 days in the hole. Yeah, but 42 days in the hole. I hear you, Sinbad. That's a great song. Let's see. That was the faces, and then also Ronnie Wood did a version of that, right? I'm thinking of the faces. Steve Marriott, 40 Days in the Hole. God, I wish I could play music while we wait. I so wish we could play music. Therapist, you know, y'all make mine not too difficult at all. Best chatters. Ah, Shirley Roth, this is the best stream and chat. You all rock. Thank you. And thank you, Shirley, for being a part of it. You know, the chat, you guys pat yourselves on the back. It's you guys too. We do what we can do, but if it wasn't for such a cool chat, this would be yet another toxic environment, you know, but it's not, which is awesome. I love it. Widespread panic. I don't think he's reading jury instructions yet, so I think it'll be end of day today before there's a chance. I don't think he's read jury instructions yet, sorry. So I think it'll be, no, he has not done, no. We're getting the jury instructions, like as soon as they come on, we get jury instructions. I can't imagine it's going to take him, what, 2 hours to read jury instructions? MG, I think they'll have a verdict tomorrow, but not today. If he's done by noon, lunchtime, that gives them 4 hours to deliberate, right? 4.5 hours to deliberate. We'll see. All right, Fala, go grab some lunch. I'm assuming you're going to go grab some lunch. Irish Amy, we are a family. All about the love. That's true. Runs with scissors. This chat is so good. Thank you. And again, thank you for making it what it is. Appreciate it. And appreciate you. Let me pull that up a little. Pammy, maybe I need to create some trouble. Pammy. Now Pammy. Aw, Sinbad. Love Chris's chat. Shirley Roth, we respect each other, which I love. I better get going or I won't be going. All right, Shirley, go. Go get your cat food. Go get your cat food. Go get some food for your kitty. Oh, Pammy, you're such a rebel. I love it. How's Black Betty? Is that how's Black Betty doing these days? Probably taking her out, right? It's got to be getting nice weather from where you are. Today it's absolutely beautiful here. It's like 75, I think, clear blue. We had that front come through and really, really nice. Yes, Shirley, scat. But hurry back. Can you refuse to moderate, Pammy? Hellcat will put you in the corner, Pammy. Conscientious objector. Nice. Yep, Black Betty's calling your name. I bet. Yep, oh, Black Betty. I so wish I could play songs on this stream without getting smacked by YouTube. Because even if I played that on my guitar right now, we would still get a copyright strike. Because I've done that before on like testing streams, or I've been in videos, you know, playing music like Stone songs or whatever, and you get a copyright strike. So you can't even like play a cover song because that's YouTube. Oh, your bus comes at 12:30. All right, yeah, you got some time. We should say, oh, Black Pammy, bam, a lamb, oh, Black Pammy. See, I gotta be careful. I can't even say that. I might get yelled at by YouTube. You gotta be so careful with songs. Ken, yeah, it's mind-boggling to me that YouTube intellectual property stuff is still that jacked up years later. I know. I don't even want to sing. I don't even want to like do anything because it's like, hey, Susan, how are you? Thank you for joining us. No, Pammy, that's right. Sinbad, I have that song on a CD. Yes, it's an older stereo. And I play it loud when I arrive somewhere, especially a toy run. Nice. I can see Pammy rolling up with on her Black Betty with that song blasting. Yep, whatever I say, don't say it. Yep, Brad, you were there. You I know of what you speak of. That's funny. That's almost a blast from the past at this point. Sinbad, Danny on saying Silent Night a cappella at Christmas and she got a copyright strike. Yeah, that's what I'm saying. Yeah, you could sing in Pig Latin. You got to be so careful. Hey, Queen Olive, how are you? It's just ridiculous. 88 keys. Just wanted to say good morning to everyone. I'm following very little of the trial, but I'm interested in the verdict. I hope that's not cheating. No, you're not cheating. Pammy, yep. Black leather, shade hair in a braid. Pammy, you're killing me. You're just killing me. I love it. Capri, I can totally imagine that too, Pammy. Pammy, you are too much. That's why we love you. Oh my gosh, the visual. It's just too funny. Ken Rosenberg says, YouTube's approach might minimize its risk to some extent, but it's significantly more aggressive than the actual law, stifles creativity. I mean, I get it. Artists want to get their money. I get it. But, I mean, if I'm playing a cover, like if right now I just started to play, can't always get what you want, I get smacked for that. It's like, Sinbad, hubby plays Black Betty on guitar too. Such a great driving song. Yep. Irish Amy, I am living for that image. Ken says, it's sort of against what intellectual property law is there to encourage in the first place. Oh, here we go. The
law. What I don't want you to do is take notes. So if you have your notebooks up, put them down. Copies of the instructions are going to be made available to each and every one of you separately. Why am I not giving it to you now? Because I want you to listen to me with all intent. You'll get them later. During the instructions, we're going to take at least one, maybe more stretch breaks. We'll get through this. Ladies and gentlemen of the jury, you have heard all the evidence and the arguments of the attorneys, and now it is my duty to instruct you on the law that applies to this case. The law requires that I read the instructions to you. You will have these instructions in written form in the jury room to refer to during your deliberations. You must base your decision on the facts and the law. You have two duties to perform. First, you must determine what facts have been proved from the evidence received in this trial and not from any other source. A fact is something proved by the evidence or by stipulation. A stipulation is an agreement between the attorneys regarding the facts. Second, you must apply the law that I state to you to the facts as you determine them, and this way arrive at your verdict and any finding that you're instructed to include in your verdict. You must accept and follow the law as I stated to you, regardless of whether you agree with it. If anything concerning the law said by the attorneys in their arguments or at any other time during the trial conflicts with my instructions, you must follow my instructions. You must not be influenced by pity for or prejudice against the defendant. You must not be biased against the defendant because she has been arrested for this offense, charged with a crime, or brought to trial. None of these circumstances is evidence of guilt, and you must not infer or assume from any or all of them that the defendant is more likely to be guilty than not guilty. You must not be influenced by sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling. Both the people and the defendant have a right to expect that you will conscientiously consider, weigh the evidence, apply the law, and reach a just verdict regardless of the consequences. If any rule, direction, or idea is repeated or stated in different ways in these instructions, no emphasis is intended and you must not draw any inference because of its repetition. Do not single out any particular sentence or any individual point or instruction and ignore the others. Consider the instructions as a whole, and each in light of all the others. The order in which the instructions are given has no significance as to their relative importance. Statements made by the attorneys during the trial are not evidence. However, if the attorneys have stipulated or agreed to a fact, you must regard that fact as proven. If an objection was sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason for the objection. Do not assume to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it helps you to understand the answer. Do not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken by the court. Treat it as though you had never heard of it. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. When a witness has testified through a certified court interpreter, you must accept the English interpretation of that testimony even if you would have translated the foreign language differently. You must not independently investigate the facts or the law, or consider or discuss facts as to which there is no evidence. This means, for example, that you must not conduct experiments, visit or view the premises or place where the crimes charged were allegedly committed, or any other premises or place involved in this case. In addition, you must not conduct research or disseminate information on any subject. You must not discuss this case with any other person, including but not limited to spouses, spiritual leaders or advisors, or therapists, except a fellow juror during deliberations when all 12 of you are together in the jury room, and then only after the case is submitted to you for your decision, and only when all 12 jurors are present in the jury room. These prohibitions against conversation, research, and dissemination include, but are not limited to, all forms of electronic or wireless communication such as radio, television, and the internet. You've been given notebooks and pencils. You will be able to take them into the jury room when you deliberate. Notes are only an aid to memory and should not take precedence over recollection. A juror who did not take notes should rely upon his or her recollection of the evidence and not be influenced by the fact that other jurors did take notes. Notes are for the note-taker's own personal use in refreshing his or her recollection of the evidence. Finally, should any discrepancy exist between a juror's recollection of the evidence and a juror's notes, or between one juror's recollection and that of another, you may request that the reporter read back the relevant testimony which must prevail. Evidence consists of the testimony of witnesses, writings, material objects, or anything presented to the senses and offered to prove the existence or non-existence of a fact. Evidence is either direct or circumstantial. Direct evidence is evidence that directly proves a fact. It is evidence which, by itself, if found to be true, establishes that fact. Circumstantial evidence is evidence that, if found to be true, proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It is not necessary that facts be proved by direct evidence. They also may be proved by circumstantial evidence, or by a combination of direct and circumstantial evidence. Both direct and circumstantial evidence are acceptable as a means of proof. Neither is entitled to any greater weight than the other. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only 1, consistent with the theory that the defendant is guilty of the crime, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance on which the inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count permits 2 reasonable interpretations, one of which points to the defendant's guilt and the other to her innocence, you must adopt that interpretation that points to the defendant's innocence and reject that interpretation that points to her guilt. If, on the other hand, one interpretation of this evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. If you find that the defendant attempted to suppress evidence against herself in any manner, such as by an offer to compensate a witness, by destroying like that. Such as by destroying evidence or by concealing evidence. This attempt may be considered by you as a circumstance tending to show a consciousness of guilt. However, this conduct is not sufficient by itself to prove guilt, and its weight and significance, if any, are for you to decide. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence or who may appear to have some knowledge of these events. Neither side is required to produce all objects or documents mentioned or suggested by the evidence. There has been evidence in this case indicating that a person other than the defendant, Robert Baker, or Christopher Austin was or may have been involved in the crime for which the defendant is on trial. There may be many reasons why that person is not here on trial. Therefore, do not speculate or guess as to why the other person is not being prosecuted in this trial, or whether he has been or will be prosecuted. Your sole duty is to decide whether the people have proved the guilt of the defendant on trial. Evidence that at some other time a witness made statements that are inconsistent or consistent with his or her testimony in this trial may be considered by you not only for the purpose of testing the credibility of the witness, but also as evidence of the truth of the facts as stated by the witness on that former occasion. If you disbelieve a witness's testimony that he or she no longer remembers a certain event, that testimony is inconsistent with a prior statement or statements by him or her describing that event. Every person who testifies under oath is a witness. You are the sole judges of the believability of a witness and the weight to be given the testimony of each witness. In determining the believability of a witness, you may consider anything that has a tendency reasonably to prove or disprove the truthfulness of the testimony of the witness, including but not limited to any of the following: the extent of the opportunity or ability of the witness to see or hear or otherwise become aware of any matter about which the witness testifies, the ability of the witness to remember or to communicate any matter about which the witness has testified, the character and quality of that testimony, the demeanor and manner of the witness while testifying, the existence or non-existence of a bias, interest, or other motive, the existence or non-existence of any fact testified to by the witness, the attitude of the witness toward this action or toward the giving of testimony, a statement previously made by the witness that is consistent or inconsistent with his or her testimony, an admission by the witness of untruthfulness, the witness's prior conviction of a felony, and whether the witness is testifying under a grant of immunity or leniency. Discrepancies in a witness's testimony, or between a witness's testimony and that of other witnesses, if there were any, do not necessarily mean that any witness should be discredited. Failure of recollection is common. Innocent misrecollection is not uncommon. Two persons witnessing an incident or a transaction often will see or hear it differently. You should consider whether a discrepancy relates to an important matter or only to something trivial. A witness who is willfully false in one material part of his or her testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all the evidence you believe the probability of truth favors his or her testimony in other particulars. You are not required to decide in any issue of fact in accordance with the testimony of a number of witnesses which does not convince you, as against the testimony of a lesser number or other evidence which you find more convincing. You may not disregard the testimony of the greater number of witnesses merely from caprice, whim, or prejudice, or from a desire to favor one side against the other. You must not decide an issue by the simple process of counting the number of witnesses who have testified on the opposing sides. The final test is not in the relative number of witnesses, but in the convincing force of the evidence. The fact that a witness has been convicted of a felony, if this is a fact, may be considered by you only for the purpose of determining the believability of that witness. The fact of a conviction does not necessarily destroy or impair a witness's believability. It is one of the circumstances that you may consider in weighing the testimony of that witness. You should give the testimony of a single witness whatever weight you think it deserves. Testimony concerning any fact by one witness which you believe, whose testimony about that fact does not require corroboration, is sufficient for the proof of that fact. You should carefully review all the evidence upon which the proof of that fact depends. The mere fact that a witness is in custody or is in physical restraint must not prejudice you for or against any party. That a witness is in custody or subject to physical restraint is not by itself evidence that a witness is or is not believable. Motive is not an element of the crime charged and need not be shown. However, you may consider motive or lack of motive as a circumstance in this case. Presence of motive may tend to establish the defendant is guilty. Absence of motive may tend to show the defendant is not guilty. A defendant in a criminal trial has a constitutional right not to be compelled to testify. You must not draw any inference from the fact that a defendant does not testify. Further, you must neither discuss this matter nor permit it to enter into your deliberations in any way. In deciding whether or not to testify, the defendant may choose to rely on the state of the evidence and upon the failure of any of the people to prove beyond a reasonable doubt every essential element of the charge against her. No lack of testimony on the defendant's part will make up for a failure of proof by the people so as to support a finding against her on any essential element. A confession is a statement made by a defendant on which she has acknowledged her guilt of the crimes for which she is on trial. In order to constitute a confession, the statement must acknowledge participation in the crimes as well as the required criminal intent or state of mind. An admission is a statement made by the defendant which does not by itself acknowledge her guilt of the crimes for which the defendant is on trial, but which statement tends to prove her guilt when considered with the rest of the evidence. You are the exclusive judges as to whether the defendant made a confession or an admission, and if so, whether that statement is true in whole or in part. Evidence of an oral confession or an oral admission of the defendant, not contained in an audio or video recording, and not made in court, should be viewed with caution. If you should find from the evidence that there was an occasion when the defendant, 1, under conditions which reasonably afforded her an opportunity to reply, 2, failed to make a denial or made false, evasive, or contradictory statements in the absence of an accusation expressed directly to her or in her presence, charging her with the crime for which this defendant now is on trial, or tending to connect her with its commission, and 3, that she heard the accusation and understood its nature, then the circumstance of her silence and conduct on that occasion may be considered against her as indicating an admission that the accusation was true. Evidence of an accusatory statement is not received for the purpose of proving its truth, but only as it supplies meaning to the silence and conduct of the accused in the face of it. Unless you find that the defendant's silence and conduct at the time indicated an admission that the accusatory statement was true, you must entirely disregard the statement. No person may be convicted of a criminal offense unless there is some proof of each element of the crime independent of any confession or admission made by her outside of this trial. The identity of the person who is alleged to have committed a crime is not an element of the crime, nor is the degree of the crime. The identity or degree of the crime may be established by a confession or admission. Witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give to any opinion expressed by an expert witness, you should consider the qualifications and the believability of the witness, the facts or materials upon which each opinion is based, and the reasons for each opinion. An opinion is only as good as the facts and reasons on which it is based. If you find that any fact has not been proved or has been disproved, you must consider that in determining the value of the opinion. Likewise, you must consider the strengths and weaknesses of the reasons on which it is based. You are not bound by an opinion. Give each opinion the weight you find it deserves. You may disregard any opinion if you find it to be unreasonable. In examining an expert witness, counsel may ask a hypothetical question. This is a question in which the witness is asked to assume the truth of the set of facts and to give an opinion based on that assumption. In permitting this type of question, the court does not rule and does not necessarily find that all of the assumed facts have been proved. It only determines that those assumed facts are within the possible range of the evidence. It is for you to decide from all of the evidence whether or not the facts assumed in a hypothetical question have been proved. If you should decide that any assumption in the question has not been proved, you are to determine the effect of that failure of the proof on the value and weight of the expert opinion based on the assumed facts. In resolving any conflict that may exist in the testimony of expert witnesses, you should weigh the opinion of one expert against that of another. In doing this, you should consider the qualifications and the believability of each witness, the reasons for each opinion, and the matter upon which it is based. Persons who are involved in committing a crime are referred to as principals in that crime. Except as to the crime of murder, each principal, regardless of the extent or manner of participation, is equally guilty. Principals include 1. Those who directly and actively commit the act constituting the crime, or 2. Those who aid and abet the commission of the crime. When the crime charged is murder, the aider and abettor's guilt is determined by the combined acts of all the participants as well as that person's own mental state. If the aider and abettor's mental state is more culpable than that of the actual perpetrator, that person's guilt may be greater than that of the actual perpetrator. Similarly, the aider and abettor's guilt may be less than that of the perpetrator's if the aider and abettor has a less culpable mental state. A person aids and abets the commission of a crime when he or she 1. With knowledge of the unlawful purpose of the perpetrator, and 2. With the intent or purpose of committing or encouraging or facilitating the commission of the act or crime, and 3. By act or advice, aids, promotes, encourages, or instigates the commission of the act or crime. A person who aids and abets the commission of a crime need not be present at the scene of the crime. Mere presence at the scene of a crime, which does not itself assist the commission of the crime, does not amount to aiding and abetting. To be guilty as an aider or abettor, the defendant's intent or purpose of committing or encouraging or facilitating the commission of the act or crime by the perpetrator must be formed before or during the commission of the act or crime. Mere knowledge that a crime is being committed and the failure to prevent it does not amount to aiding and abetting. An accomplice is a person who was subject to prosecution for the identical offense charged against the defendant on trial by reason of aiding and abetting or being a member of a criminal conspiracy. You cannot find the defendant guilty based upon the testimony of an accomplice unless that testimony is corroborated by other evidence which tends to connect the defendant with the commission of the offense. Testimony of an accomplice includes any out-of-court statement purportedly made by an accomplice, received for the purpose of proving that what the accomplice stated out of court was true. To corroborate the testimony of an accomplice, there must be evidence of some act or fact related to the crime which, if believed, by itself and without any aid, interpretation, or direction from the testimony of the accomplice, tends to connect the defendant with the commission of the crime charged. However, it is not necessary that the evidence of corroboration be sufficient in itself to establish every element of the crime charged, or that it corroborate every fact to which the accomplice testifies. In determining whether an accomplice has been corroborated, you must first assume the testimony of the accomplice has been removed from the case. You must then determine whether there is any remaining evidence which tends to connect the defendant with the commission of the crime. If there is no independent evidence which tends to connect the defendant with the commission of the crime, the testimony of the accomplice is not corroborated. If there is independent evidence which you believe, then the testimony of the accomplice is corroborated. Required corroboration of the testimony of an accomplice may not be supplied by the testimony of any or all of his accomplices, but must come from other evidence. If the crime of murder or conspiracy to commit murder was committed by anyone, the witnesses Robert Baker and Christopher Austin were accomplices as a matter of law, and their testimony is subject to the rule requiring corroboration. To the extent that an accomplice gives testimony that tends to incriminate the defendant, it should be viewed with caution. This does not mean, however, that you may arbitrarily disregard that testimony. You should give that testimony the weight you think it deserves after examining it with care and caution and in light of all the evidence in this case. In the crimes and allegations charged, there must exist a union or joint operation of act or conduct and a certain specific intent or mental state in the mind of the perpetrator. Unless this specific intent or mental state exists, the crime or allegation to which it relates is not committed or is not true. The specific intent or mental state required is included in the definitions of the crimes or allegations set forth elsewhere in these instructions. A defendant in a criminal action is presumed to be innocent until the contrary is proved. In the case of a reasonable doubt whether her guilt is satisfactorily shown, she is entitled to a verdict of not guilty. This presumption places upon the people the burden of proving her guilty beyond a reasonable doubt. Reasonable doubt is defined as follows. It is not a mere possible doubt, because everything relating to human affairs is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction of the truth of the charge. Let's stretch. The defendant is accused of count 1 of having committed the crime of murder, a violation of section 187 of the Penal Code. Every person who unlawfully kills a human being with malice aforethought is guilty of the crime of murder in violation of Penal Code section 187. A killing is unlawful if it was neither justifiable nor excusable. In order to prove this crime, each of the following elements must be proved. 1. A human being was killed. 2. The killing was unlawful. And 3. The killing was done with malice aforethought. Malice may be either express or implied. Malice is expressed when there is manifested an intention unlawfully to kill a human being. Malice is implied when 1. The killing resulted from an intentional act. 2. The natural consequences of the act are dangerous to human life. And 3. The act was deliberately performed with knowledge of the danger to, and with conscious disregard for human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state need be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person killed. The word aforethought does not imply deliberation or the lapse of a considerable time. It only means that the required mental state must precede rather than follow the act. Murder is classified into 2 degrees. If you should find the defendant guilty of murder, you must determine and state in your verdict whether you find the murder to be of the first or second degree. All murder which is perpetrated by any kind of willful, deliberate, and premeditated killing with express malice aforethought is murder of the first degree. The word willful, as used in this instruction, means intentional. The word deliberate, which relates to how a person thinks, means formed or arrived at or determined upon as a result of careful thought and weighing of consideration for and against the proposed course of action. The word premeditated relates to when a person thinks and means considered beforehand. One premeditates by deliberating before taking action. If you find that the killing was preceded and accompanied by a clear, deliberate intent on the part of the defendant to kill, which was a result of deliberation and premeditation, so it must have been formed upon pre-existing reflection and not under a sudden heat of passion or the condition precluding the idea of deliberation, it is murder of the first degree. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. To constitute a deliberate and premeditated killing, the slayer must weigh and consider the question of killing and the reasons for and against such a choice, and having in mind the consequences, he or she decides to and does kill. Murder which is immediately preceded by lying in wait is also murder of the first degree. The term lying in wait is defined as a waiting and watching for an opportune time to act, together with a concealment by ambush or by some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration be substantial. That is, an amount of time that shows the killer had a state of mind equivalent to premeditation or deliberation. The word deliberation relates to how a person thinks. It means formed or arrived at or determined upon as a result of careful thought and weighing of consideration for and against the proposed course of action. The word premeditation, which relates to when a person thinks, means considered beforehand. One premeditates by deliberating before taking action. Murder of the second degree is the unlawful killing of a human being with malice aforethought, when the perpetrator intended unlawfully to kill a human being, but the evidence is insufficient to prove deliberation and premeditation or lying in wait. Murder of the second degree is also the unlawful killing of a human being, when 1. The killing resulted from an intentional act, 2. The natural consequences of the act are dangerous to human life, and 3. The act was deliberately performed with knowledge of the danger to and with conscious disregard for human life. When the killing is the direct result of such an intentional act, it is not necessary to prove that the defendant intended that the act would result in the death of a human being. If any juror is convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but has a reasonable doubt whether the murder was of the first or the second degree, that juror must give the benefit of that doubt, must give the defendant the benefit of that doubt and find the murder to be of the second degree. If you find the defendant in this case guilty of murder of the first degree, you must then determine if one or more of the following special circumstances are true or not true: murder for financial gain and murder by means of lying in wait. The people have the burden of proving the truth of a special circumstance. If you have a reasonable doubt as to whether a special circumstance is true, you must find it to be not true. You cannot find a special circumstance to be true unless you are satisfied beyond a reasonable doubt that such defendant with the intent to kill aided, abetted, counseled, commanded, induced, solicited, requested, or assisted any actor in the commission of the murder in the first degree. You must decide separately each special circumstance alleged in this case. If you cannot agree as to all of the special circumstances, but can agree as to one, you must make your finding as to the one upon which you agree. In order to find a special circumstance alleged in this case to be true or untrue, you must agree unanimously. You will state your special finding as to whether the special circumstance is or is not true on a form that will be provided. To find that the special circumstance referred to in these instructions as murder for financial gain is true, each of the following facts must be proved. 1. The murder was intentional. 2. It was carried out for financial gain. And 3. The defendant believed the death of the victim would result in the desired financial gain. To find that the special circumstance referred to in these instructions as murder by means of lying in wait is true, each of the following facts must be proved. 1. The defendant intentionally killed the victim. And 2. The murder was committed by means of lying in wait. Murder which is immediately preceded by lying in wait is a murder committed by means of lying in wait. The term lying in wait is defined as a waiting and watching for an opportune time to act, together with concealment by ambush or some other secret design to take the other person by surprise, even though the victim is aware of the murderer's presence. The lying in wait need not continue for any particular period of time, provided that its duration be substantial, and that an amount of time that shows the killer had a state of mind equivalent to premeditation or deliberation. The word premeditation relates to when a person thinks and means considered beforehand. The word deliberation, which relates to how a person thinks, means formed or arrived at or determined upon as a result of careful thought and weighing of considerations for and against the proposed course of action. A person premeditates by deliberating before taking action. You are not permitted to find a special circumstance alleged in this case to be true based on circumstantial evidence unless the proved circumstance is not only 1, consistent with the theory that a special circumstance is true, but 2, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the truth of a special circumstance must be proved beyond a reasonable doubt. In other words, before an inference essential to establish a special circumstance may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which that inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence is susceptible of two reasonable interpretations, one of which points to the truth of a special circumstance and the other to its untruth, you must adopt the interpretation which points to its untruth and reject the interpretation which points to its truth. If, on the other hand, one interpretation of that evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. In your deliberations, the subject of penalty or punishment is not to be discussed or considered by you. That it is a matter which must not in any way affect your verdict or affect your finding as to the special circumstances alleged in this case. The defendant is accused in count 2 of having committed the crime of a conspiracy to commit murder in violation of section 182, subdivision A, subdivision 1 of the Penal Code. Every person who conspires with any other person or persons to commit the crime of murder is guilty of a violation of Penal Section 182, subdivision A, subdivision 1, a crime. Murder is the unlawful killing of a human being with malice aforethought. A conspiracy to commit murder is an agreement entered into between two or more persons with the specific intent to agree to commit the crime of murder and with the further specific intent to commit that murder, followed by an overt act committed in this state by one or more of the parties for the purpose of accomplishing the object of the conspiracy. Conspiracy is a crime. The crime of conspiracy to commit murder requires proof that the conspirators harbored express malice aforethought, namely the specific intent to kill unlawfully another human being. In order to find a defendant guilty of conspiracy, in addition to proof of the unlawful agreement and specific intent, there must be proof of the commission of at least one of the acts alleged in the information, strike that, in the indictment, to be an overt act, and that the act found to have been committed was an overt act. It is not necessary to the guilt of any particular defendant that the defendant personally committed an overt act if she was one of the conspirators when the overt act was committed. The term overt act means any step taken or act committed by one or more of the conspirators which goes beyond mere planning or agreement to commit a crime, and which step or act is done in furtherance of the accomplishment of the object of the conspiracy. To be an overt act, the step taken or act committed need not in and of itself constitute the crime or even an attempt to commit the crime which is the ultimate object of the conspiracy. Nor is it required that the step or act in and of itself be criminal or an unlawful act. The jury need not be unanimous as to which particular overt act was proved, as long as the jury is unanimous that at least one overt act was proved. In order to prove this crime, each of the following elements must be proved. 1. Each of the persons entered into an agreement to kill unlawfully another human being. 2. Each of the persons specifically intended to enter into an agreement with one or more other persons for that purpose. 3. Each of the persons to the agreement harbored express malice aforethought, namely a specific intent to kill unlawfully another human being. And 4. An overt act was committed in this state by one or more of the persons who agreed and intended to commit murder. Each member of a criminal conspiracy is liable for each act and bound by each declaration of every other member of the conspiracy if that act or declaration is in furtherance of the object of the conspiracy. The act of one conspirator pursuant to or in furtherance of the common design of the conspiracy is the act of all conspirators. The formation and existence of a conspiracy may be inferred from all of the circumstances tending to show the common intent and may be proved in the same way as any other fact may be proved, either by direct testimony of the fact or by circumstantial evidence, or by both direct and circumstantial evidence. It is not necessary to show a meeting of the alleged conspirators or the making of an express or formal agreement. Evidence that a person was in the company of or associated with one or more other persons alleged or proved to have been members of a conspiracy is not in itself sufficient to prove that person was a member of the alleged conspiracy. It is not a defense to the crime of conspiracy that an alleged conspirator did not know all the other conspirators. The member of a conspiracy may be widely separated, or the members of a conspiracy may be widely separated geographically, and yet may be in agreement on a criminal design and may act in concert in pursuit of that design. The adoption by a person of the criminal design and criminal intent entertained in common by others and of its object and purposes is all that is necessary to make that person a co-conspirator with the required elements of a conspiracy are present, when the required elements of a conspiracy are present. Where a conspirator commits an act or makes a declaration which is neither in furtherance of the object of the conspiracy, nor the natural and probable consequence of an attempt to attain that object, he or she alone is responsible for and is bound by that act or declaration, and no criminal responsibility therefore attaches to any of his or her confederates. The act or declaration of a person who is not a member of a conspiracy is not binding upon the members of the conspiracy, even if the act or declaration tended to promote the object of the conspiracy. Evidence of the commission of an act which furthered the purposes of an alleged conspiracy is not in itself sufficient to prove that the person committing the act was a member of the alleged conspiracy. No act or declaration of a conspirator committed or made after the conspiracy has been terminated is binding upon co-conspirators, and they are not criminally liable for that act. In this case, the defendant is charged with conspiracy to commit the crime or the following public crime: murder. It is alleged that the following overt acts were committed in the state by one or more of the defendants and were overt acts and committed for the purpose of furthering the object of the conspiracy. 1. Defendant Monica Sementilli and her lover, Robert Louis Baker, agreed to kill defendant Monica Sementilli's husband, Fabio Sementilli. 2. Defendant Monica Sementilli and Robert Louis Baker planned to obtain victim Fabio Sementilli's life insurance proceeds after he was murdered. 3. Defendant Monica Sementilli and Robert Louis Baker planned to live together once victim Fabio Sementilli was dead. 4. Defendant Monica Sementilli and Robert Louis Baker communicated via cell phones and encrypted communication applications regarding their plan to kill victim Fabio Sementilli. 5. Defendant Monica Sementilli called Robert Louis Baker over 9,000 times over the course of the year preceding the murder of her husband, Fabio Sementilli. 6. Robert Louis Baker called defendant Monica Sementilli over 17,000 times over the course of the year preceding the murder of victim Fabio Sementilli. 7. Robert Louis Baker solicited an unknown co-conspirator to assist him in killing victim Fabio Sementilli. 8. Defendant Monica Sementilli met with representatives from First Digital Surveillance to upgrade and install remote access to a residential video surveillance system on June 28, 2016. 9. Subsequently, on June 28, 2016, defendant Monica Sementilli requested assistance from First Digital Surveillance via text message to set up remote access to her residential video surveillance system via her cell phone. 10. Monica Sementilli received a digital DVR instruction manual from First Digital Surveillance to enable her to remotely view her residential video surveillance security cameras live via her cell phone. 11. Defendant Monica Sementilli sent a text message on June 28, 2016 to the owner of First Digital indicating she was able to connect her cell phone to her home surveillance system for remote access. 12. Defendant Monica Sementilli forwarded an email containing her security password, IP address, username, and instruction manual on how to access her home video surveillance system to her lover, Robert Louis Baker, on June 28, 2016. 13. Both defendant Monica Sementilli and Robert Louis Baker downloaded the computer application, allowing them to live stream the Sementilli home surveillance security cameras from their cell phones while simultaneously having a FaceTime communication. 14. defendant Monica Sementilli described and or showed the location of the DVR in her garage to Robert Louis Baker. 15. Defendant Monica Sementilli notified Robert Louis Baker that victim Fabio Sementilli would be alone at home during the afternoon on January 23, 2017. 16. Defendant Monica Sementilli and Robert Louis Baker communicated via cell phone 23 times between January 18, 2017 and January 25, 2017. 17. On January 23, 2017, defendant Monica Sementilli went to the Woodland Hills LA Fitness Gym in order to make contact with Robert Louis Baker. 18. On January 23, 2017, defendant Monica Sementilli confirmed that her housekeeper would be finished cleaning and leave the Sementilli residence by 2:30 p.m. so that there would be no witnesses present for the murder of her husband, victim Fabio Sementilli, by Robert Louis Baker. 19. On January 23, 2017, ensured that her oldest daughter, Jessica Sementilli, would be out of the home at a babysitting job in the afternoon so as to leave victim Fabio Sementilli alone without any witnesses present so he could be murdered by Robert Louis Baker. 20. Defendant Monica Sementilli drove to Target in Woodland Hills in order to meet with Robert Louis Baker and establish her alibi. 21. Defendant Monica Sementilli entered the Target parking lot at approximately 3:30 p.m. and picked up Robert Louis Baker and parked her car in a remote area of the lot. 22. After Robert Louis Baker got out of defendant Monica Sementilli's vehicle, defendant Monica Sementilli reparked in the Target parking lot near the store. 23. While in the Target parking lot, defendant Monica Sementilli sat in her car and called her daughter, Jessica, to coordinate the available murder timeline with Robert Louis Baker. 24. Defendant Monica Sementilli entered Target at 3:38 p.m. and remained inside for approximately 1 hour to establish her alibi. 25. While at Target at approximately 4 o'clock p.m., defendant Monica Sementilli used her cell phone to connect to her home IP address and monitor her home surveillance cameras utilizing significant amounts of data. 26. At approximately 4:18 p.m., Robert Louis Baker and an unknown co-conspirator jogged up to victim Fabio Sementilli's home from Oakdale Avenue to Queen Victoria Road while armed with a knife. 27. Upon arriving at the Sementilli home, Robert Louis Baker checked the surveillance security cameras via his cell phone to attempt to determine victim Fabio Sementilli's location at the residence. 28. Robert Louis Baker and an unknown co-conspirator entered the residence. 29. After leaving Target at approximately 4:36 p.m., defendant Monica Sementilli went to the Ralph's Market in Woodland Hills in order to establish another alibi. 30. Upon entering the Sementilli residence, Robert Louis Baker and an unknown co-conspirator walked into the living room, dining room, and or kitchen and observed victim Fabio Sementilli sitting on the back patio through the windows. 31. Robert Louis Baker and an unknown co-conspirator attacked victim Fabio Sementilli from behind as he sat with his back to the kitchen door. 32. While stabbing victim Fabio Sementilli to death, Robert Louis Baker cut his left index finger. 33. Robert Louis Baker and an unknown co-conspirator murdered victim Fabio Sementilli in furtherance of the conspiracy with defendant Monica Sementilli to collect the victim's life insurance proceeds. 34. Robert Louis Baker went into the kitchen to wash off the victim's blood and destroy evidence, leaving his own blood behind. 35. Robert Louis Baker and an unknown co-conspirator attempted to clean the crime scene and destroy evidence. 36. Robert Louis Baker and an unknown co-conspirator attempted to stage a robbery and or burglary in the master bedroom. 37. Robert Louis Baker and an unknown co-conspirator went into the garage and removed the DVR for the home surveillance security system from the top of cabinet as previously described and pointed out by defendant Monica Sementilli. 38. Robert Louis Baker and an unknown co-conspirator turned off the circuit breakers in the garage, cutting off power to the home. 39. At approximately 4:53 p.m., Robert Louis Baker and an unknown co-conspirator took and drove away victim Fabio Sementilli's Porsche 911 from the residence to stage the crime scene as a robbery and or burglary. 40. 4 hours later, Robert Louis Baker parked victim Fabio Sementilli's Porsche on Khalifa Street in Woodland Hills in order to stage the crime as a robbery and or burglary and fled the scene. 41. Defendant Monica Sementilli left the Ralph's Market at approximately 4:52 p.m. 42. Defendant Monica Sementilli waited for her younger daughter, Isabella, to arrive home first and find her father's body at approximately 4:55 p.m. 43. Defendant Monica Sementilli coordinated the time with Robert Louis Baker so she would arrive home immediately after her daughter at approximately 5:03 p.m. 44. On January 23, 2017, defendant Monica Sementilli lied to LAPD detective Parshall that she was unaware that she had killed her husband. 45. After the murder on January 23, 2017, defendant Monica Sementilli contacted victim Fabio Sementilli's company, Wella Professionals / Cody, through a friend to make a claim for his life insurance policy proceeds. 46. Subsequently, defendant Monica Sementilli contacted Met Life Insurance and Wella Professional / Cody to make claims for her husband's life insurance policy proceeds. 47. After the murder, defendant Monica Sementilli called LAPD detectives several times inquiring why her husband's life insurance policy proceeds were being withheld. 48. On January 29, 2017, at a gathering at her home, after the funeral, defendant Monica Sementilli and Robert Louis Baker went into the master bedroom to discuss and arrange their continuing fabricated stories to law enforcement, friends, and family. 49. On May 18, 2017, defendant Monica Sementilli told LAPD detective Parshall, Tellis, and Gable that she desperately needed her husband's life insurance policy money in order to continue to run her household, despite secretly spending money on travels with Robert Louis Baker. 50. On May 18, 2017, defendant Monica Sementilli lied to LAPD RHD detectives Tellis and Gable, pretending that she was uncertain of the last name of her lover and co-conspirator, Robert Louis Baker. 51. On May 18, 2017, defendant Monica Sementilli lied to LAPD RHD detectives that she did not know how to access her home surveillance system remotely via her cell phone. 52. Between March 26 and March 28, 2017, defendant Monica Sementilli posted photographs and statements indicating her alleged sadness over the death of her husband in order to provide a cover for her participation in the murder while having sexual relations with Robert Louis Baker in a Las Vegas hotel room. 53. Defendant Monica Sementilli called her husband's older son, Luigi Sementilli, and requested $30,000 from one of the victim Fabio Sementilli's life insurance policies. 54. Defendant Monica Sementilli contacted her husband's family and requested their assistance in obtaining money from her husband's life insurance policies and asked them to draft a letter to Met Life Insurance Company and Wella Professionals / Cody via Detective Parshall on her behalf. 55. Defendant Monica Sementilli and Robert Louis Baker manufactured a false story to explain away the DNA evidence recovered at the crime scene belonging to defendant Robert Louis Baker. 56. Defendant Monica Sementilli and Robert Louis Baker lied to law enforcement and pretended they were uninvolved in the murder of victim Fabio Sementilli so they could avoid arrest and prosecution and collect his life insurance proceeds. Evidence of a statement made by one alleged conspirator other than at this trial shall not be considered by you against another alleged conspirator unless you determine by preponderance of the evidence that 1. That from the other independent evidence that at the time the statement was made, a conspiracy to commit a crime existed. 2. That the statement was made while the person making the statement was participating in the conspiracy. 3. That the statement was made in furtherance of the objective of the conspiracy and was made before or during the time when the party against whom it was offered was participating in the conspiracy. And the word statement as used in this instruction includes any oral or written verbal expression or the nonverbal conduct of a person intended by that person as a substitute for oral or written verbal expression. Let's stretch again. Each count charges a distinct crime. You must decide each count separately. The defendant may be found guilty or not guilty of either or both of the crimes charged. Your finding as to each count must be stated in a separate verdict. I have not intended by anything I have said or done, or by any questions that I may have asked, or by any ruling I may have made to intimate or suggest what you should find to be the facts, or that I believe or disbelieve any witness. If anything I have done or said that seems to indicate, you will disregard it and form your own conclusion. The purpose of the court's instructions is to provide you with the applicable law so that you may arrive at a just and lawful verdict. Whether some instructions apply will depend upon what you find to be the facts. Disregard any instruction which applies to facts determined by you not to exist. Do not conclude that because an instruction has been given that I am expressing an opinion as to the facts. The people and the defendant are entitled to the individual opinion of each juror. Each of you must consider the evidence for the purpose of reaching a verdict if you can do so. Each of you must decide the case for yourself, but should do so only after discussing the evidence and the instructions with the other jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, do not decide any question in a particular way because a majority of the jurors, or any of them, favor that decision. Do not decide any issue in this case by the flip of a coin or by any other chance determination. The attitude and conduct of jurors at all times are very important. It is rarely helpful for a juror at the beginning of the deliberations to express an emphatic opinion on the case or to announce a determination to stand for a certain verdict. When one does that at the outset, a sense of pride may be aroused and one may hesitate to change a position even if shown that it is wrong. Remember that you are not partisans or advocates in this matter. You are the impartial judges of the facts. In your deliberations, do not discuss or consider the subject of penalty or punishment. That subject must not in any way affect your verdict. During deliberations, any question or request you may have should be addressed to the court on a form that will be provided. If there is any disagreement as to the actual testimony, you have the right, if you choose, to request a readback by the reporter. You may request a partial or a total readback, but any readback should be a fair presentation of that evidence, and if a readback of testimony is requested, the reporter will delete objections, rulings, and sidebar conferences so that you will hear only the evidence that was actually presented. Please understand that counsel must first be contacted, and it may take time to provide a response or a readback. Continue deliberating until you are called back into the courtroom. The instructions which I am now giving to you will be made available in written form for your deliberations. They must not be defaced in any way. You will find that the instructions may be typed, printed, or handwritten. Portions may have been added or deleted. You must disregard any deleted part of an instruction and not speculate as to what it was or as to the reason for its deletion. You are not to be concerned with the reasons for any modification. Every part of the text of an instruction, whether typed, printed, or handwritten, is of equal importance. You are to be governed only by the instruction in its final wording. Do not disclose to anyone outside the jury, not even to me or any member of my staff, how, either orally or in writing, how you may be divided numerically in your balloting as to any issue unless I specifically direct otherwise. You will be permitted to separate at the noon and evening recesses. During your absence, the courtroom will be locked. You are to return following the recess at 1:30 p.m. and at 9 o'clock a.m. on the next succeeding court date. During periods of recess, it is your duty not to conduct research, disseminate information, or converse among yourselves or with anyone else on any subject connected with this trial or to form or express an opinion about the case until the cause is finally submitted to you. This prohibition on research, dissemination of information, and conversation includes, but is not limited to, any form of electronic or wireless communication, such as radio, television, and the Internet. You must not deliberate further upon the case until all 12 of you are together and reassembled in the jury room. At that time, you shall notify the clerk or the bailiff that the jury is reassembled, and then continue your deliberations. During deliberations, the bailiff will not permit any person to speak to or communicate with any juror. Consistent with that requirement, jurors must not take any electronic communication device, including but not limited to cellular telephones, into the jury deliberation room, or you must turn them off completely. These devices must not be used in any manner in the jury room. Emergency messages can be communicated to the court and will be immediately delivered to the affected jurors. As to the alternate jurors, you are still bound by the admonition that you are not to converse among yourselves or with anyone else on any subject connected with this trial, or to form or express any opinion on it until the case is submitted to you, which means until such time as you are substituted in for one of the 12 jurors now deliberating on this case. This also means that you are not to decide how you would vote if you were deliberating with the other jurors. You shall now retire and select one of your number to act as foreperson. He or she will preside over your deliberations. In order to reach verdicts, all 12 jurors must agree to the decision and any finding that you have been instructed to include in your verdict. Do not let bias, prejudice, or public opinion influence your decision. Bias includes bias against the alleged victim or victims, witnesses, or defendant based upon his or her disability, gender, nationality, race or ethnicity, religion, gender identity, or sexual orientation. As soon as you agreed upon a verdict, each may state truthfully that the verdicts express his or her vote, have them dated and signed by your foreperson, and then return with them to this courtroom. Return any unsigned verdict forms. Please swear the bailiff.
Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court? And when they have agreed upon a verdict, you will return them to the court. And furthermore, do you solemnly swear that you will take charge of the alternate jurors and keep them apart from the jury while they are deliberating on the case until otherwise instructed by the court, so help you God?
I do. Jurors 1 through 12, take your notebooks and your belongings. Go into the jury room, elect a foreperson, and the bailiff will be with you momentarily. As to the alternates, please leave your notebooks on your chairs, go outside, have a seat, and the bailiff will be with you momentarily.
All right, we are officially in verdict watch. I got a 1:11 Eastern start. So
It's going to be stipulated among counsel that the jury and all to be admonished and excused at the end of each day of deliberations without the presence of the defendant or counsel by the people and the defense.
Yes.
My first duty is to the jury. With that in mind, I do not intend to keep them waiting. So I would ask counsel or a representative of counsel to remain at all times to be available. With that same vein, I understand that family and interested parties want to be present. And that's fine too, but I'm not going to wait for them. My first duty, again, is to the jury. They can remain in the hallway, in the courtroom, or at the district attorney's office as you see fit. Thank you all.
Thank you. How much time? Half hour, 20 minutes? What's your estimates?
Immediately.
Immediately. Okay.
You understand that we have people from out of town and
To have them, you're going to have them either in the courthouse. Again, my first duty is to the jury. And I will not keep them waiting to have interested parties come here. Thank you all.
what about the stipulation about having reread done out of you?
That's up to you. I could be glad to take the stipulation now, take it as it comes.
We're happy to give it now, and then we could always, I assume, change it based on
The
the
stipulation
question.
means as far as your client or counsel? Or client and counsel? You tell me. The client does not have a constitutional right to be present.
No, we would stipulate that neither counsel nor client need be present when readback is being read by the court reporter and can be done so in the jury deliberation room as long as we can change that based on each question.
All right, is that agreeable to the people?
Yes.
Agreeable to you, ma'am?
Yes.
Very good. Thank you.
Take care.
I need one from each side.
All right, there you have it. All right, so it took about an hour, just like 59 minutes, basically an hour, for a judge to go through his jury instructions. So I have a 1:11 start. So you see the verdict clock there. He starts out by saying, "Put your notes down. I want you to listen to me." He was very commanding. He accidentally called her a criminal. He read 56. What were those that he read? I tried to go back to what he was saying. I couldn't quite pick out what he was saying there. Like, why did he? What were all those things that he read? I didn't quite get that. But anyway, whatever they were, he read 56 of them. I don't think those were the charges. Those were just, they had to prove that, I guess. It took an hour for instructions, 1:11 starts. And he wants people, he will not keep the jury waiting. When the verdict comes in, it's going to be immediate. There's not going to be a 15-minute, 10-minute, 20-minute, half hour. Usually there's like a little bit of time for people to get back into the room, but no. All right, so there we go. 1:11 start. Squeegee looks younger from this angle. Do I? It was no accident. What was no accident? I missed that. Can we rewatch it and slow it down a tad? Sorry, that'll be on you. 56 overt acts. Thank you. Thank you. The overt acts is one of the 2 traditional requirements for conspiracy. Thank you. Ken, and thank you, OnlyFan. Appreciate that. YB, I liked the list of overt acts. Okay, so thank you guys. Yeah, I missed that. I rewound it a couple times. I didn't. So 56 overt acts. Gotcha. Let me update my overt acts. All right, so just so you guys know, we're going to keep this stream going. I normally sit over here, right? This is where I normally sit. So we're going to be dual streaming. So this stream is going to be on Verdict Watch, as you can tell and see. And then over here, we're going to be on Lori Daybell, which starts at 2 o'clock our time, 2 o'clock Eastern, but we'll go on at like 10 till. So have 40 minutes or so. So you're going to see me. I'm going to be sitting over here talking. I'll be talking to you over here, and then we'll have an eyeball over here. So when the verdict does come in, the votes. How long do you think it'll take? Should I end the poll yet? Did everyone vote? We have 114 votes. If you haven't voted yet, go ahead. I'll let it roll. I'll just let it roll. Like the Doors say, let it roll. Seems like it's a Roadhouse Blues kind of day. Keep your eyes on the road, your hand upon the wheel. That goes to you, Hellcat. That was for you. Able 99, head on the swivel. Luckily, I've got this groovy chair. I got this wonderful chair that the mods got me, and Krista Limited Edition, and Pammy. Everybody pitched in for this. Yes. Fair pitch, 2 computers open, each on a different stream. Irish Amy, I have no tech knowledge, so this dual streaming is like magic to me. Yep. So 2 computers open. This computer number 1, computer number 2. So when you put on Lori, I'll be talking to you here, and then we'll be over here too. We'll have to pause Lori to be at the verdict. Exciting day. I'm not pausing anything. That's up to you. You guys can pause whatever you want. I'm going to be We're going to be streaming as long as we don't drop any frames and our computers don't blow up. Susan says, or Sinbad, wait, no. Susan, it's early in California, so they'll have all day. Baca, will we go back for any jury questions? We're staying here, you guys. I'm not going anywhere. So if you want to have 2 windows open and watch both trials, that's up to you. We will be here until we get a verdict or they end for the day, and then Lori, we will be streaming live. So we have Swirly the squeegee of justice today. Rachel, camera 1 closes one eye, camera 2 closes other eye. YB, let's see, wait, where'd you go? YB, verdict day. Imagine the conversations happening right now. I know. Dreama, she is super guilty. After lunch, well, let's see, it's, what's it, 10 o'clock there? Yeah, 10, 11, 12, 1. It's just after 10 o'clock. So I'm thinking, I'm going with, I did 2 to 4 hours. I'm thinking 3. I would say 3 hours, right? Baca, gotcha. Hey, Gordon, Doors mixed with John Lee Hooker on YouTube. Nice. I saw John Lee, never saw the Doors. That was, well, I was born at that time, but I was way too young to go see them. K-Swan, good to see you. Hopefully we get a verdict today. Abel is asking what you got planned next. As far as what? After this? Well, Lori, we're going to continue on with Lori. She's going to go probably another 4 weeks. This is just week 1. So she'll probably go another 4 weeks. Rachel, if they have a question about evidence, I am going to highly question the abilities of these jurors. Yeah, that is true. Therapists, you know, they haven't been able to talk about any of this until right now. That's crazy to think about. I agree. That is nuts. We've been talking about it for 42 days. Can you imagine? Willow Johnson, I don't have 2 screens, so can someone please keep me updated if we get a verdict today? Please and thank you. Yeah, in Lori. Okay, if we get a verdict, I'm not going to pause Lori's stream, but I'll let you guys, whoever's watching in Lori, come over to Lori, and then when there's a verdict here, I'm not going to redirect anybody. We'll stay on Lori, but I'll just say, hey guys, if you want to pop over. Yeah, OnlyFan, I can't wait for jury interview. That's true. YB, great coverage and chat right here. Oh, thank you. K-Swan, I am sure they are ready. I am sure they are ready to go home too. Widespread panic. I said 4 to 6 only because I think they'll want dinner brought in for them. Brad, does Comcast know you're going to have multiple streams? We've done it before. We have done it before. We did it before I actually came on stream. We only did it once when I was on stream, and it was only for like an hour. But we have dual streamed. We dual streamed Sarah Boone. We were doing Leilani Simon, I think, also at that time. And we did Louisima, and there was somebody else we were dual streaming. So we have done it before. So we'll see. Oh, Kohlberger, Richens, Adelson. Oh, after Lori. Well, Corey Richens has been kicked out indefinitely. We just found that out. Next up would be. Well, I was hoping to do Corey in May, but we gotta. Yeah, Donna's not until June, so that's a good question. What are we going to do after Lori? Well, Lori has the second one, the Brandon Boudreau. That's also in May. We'll have to see. We'll have to see what's going on. YB, I think Lori case will implode into mistrial. They're dropping like flies over there, right? The jurors are dropping like flies. Thank you, Baca. Appreciate it. Oh, and no, somebody who said no spoilers. Fala, yeah, if you watch the verdict, you can't come to Lori and spoil. That is true. Please, no spoilers. But I will tell you in Lori, I will say the verdict is in for Monica. If you want to come over, please come over. No spoilers. I will absolutely do that. Corey asked for an appeal. She wanted a change of venue. I think Aaron posted that on our community, right? Oh, where? Okay. Okay, so we found out at midnight. So she wanted to change a venue, and judge denied it, and they're appealing that. And he said, and they had a hearing, I think, 2 days ago, and she wants to appeal it. So he's like, "Are you sure?" And he said that could take years. And yeah, she wants to appeal the change of venue. So it got kicked out until she wins her appeal, and you know how long appeals take. So, yep, change of venue. So, oh, Ken explained it. Thank you, Krista. Appreciate it. Appreciate that you're with us on this journey, this crazy journey. Yep, no venue change. So she's in jail. She wanted a venue change. Judge said no. She's appealing it, and that could take however long an appeal takes. So let's see. So she asked for a change of venue. Judge Daddy said no. Her team appealed it. Appeals are going to take however long an appeal takes. We know appeals aren't in weeks. Or maybe, I don't know, who knows? Lena, no, I will. I won't. But I appreciate that. Let's see. Ann just says, I think Lori will become unglued when family members of this deceased start taking the stand. She won't be able to deal with it. Sometimes called an interlocutory. Is that how that's pronounced? Interlocutory appeal. I think that's the way it is. Yeah, it just happened like 2 days ago, 2 or 3 days ago. We just found out last night at midnight. So we were going to cover, she was going to have so Friday, because we're hoping Monica will be done by Friday, we were going to do Shanna Gardner. She had a pretrial. We're going to do that on Friday. And we were also going to do Corey, but since, well, we may still. Yeah, maybe we'll still do Corey on Friday. Thank you. Thank you, Ken. OnlyFans says they mentioned they're asking for an emergency appeal for a few weeks. All right. So maybe Friday we'll do that trial or that hearing, because we want to cover. I wanted to do Corey. So Friday, this is all dependent on if Monica comes back. I'm thinking they'll come back before Friday anyway. We'll do Shanna Gardner. She had a pretrial on Tuesday. So she had a pretrial on Tuesday. So we'll do that on Friday, and then we'll do Corey, whatever she had, whenever that was, Monday or Tuesday. We'll do that as well. Stephen Stearns, that got kicked down the road too. OnlyFan, I think you are more familiar with that than I am. Yeah, RA was going to Corey. Yes, he was going to go to Corey. Well, as I said earlier, if I play anything as far as a cover, I will get copyright strike. Our channel will get copyright. I can't. I'd have to do it like a members only. I'd have to do it, and or do it and not get not be monetized. So I'm not going to do that here. So some of you may have seen when I had my sister and her husband on, and we played just some random blues songs, and we got copyright struck for that. So you can't even do that. So it'll have to be a members only, or I'll have to just yeah. I'm still working on that. I'm still trying to figure out how I can get music to you guys without it being copyright strike. So therapist, that's it. We're going to write our own song. Yeah, I mean, I guess, yeah, we could do originals. But so as much as I would love to just sit and jam with you guys, but we're gonna get copyrighted strike. Serious question. Then how does my boyfriend listen to people playing their guitar songs over and over and over and over and over and over? I don't know. And I also don't know what. Like the music teachers, like they show, like I do that a lot. I'll be like, how do you play this song, that song? I don't know how they don't get. Maybe it's either they're not monetized or it's a members only. Yeah, I don't know. They're probably not monetized. All I know is every time I've tried to play a song on a stream, I've gotten copyright strike. My nephew passed away, and we did a celebration of life, and we did Wild Horses. It was my niece who came in from France with her husband. It was Paul, he played. Rebecca, she sang. My nephew, Nick, he played, he sang. Actually, yeah, everybody sang a song, and all those songs got copyright strike. And the one I remember was, my niece sang a French song, I forget the name of it. We did Wild Horses, and we got copyright strike for it. So, go figure. Or I could write you a song. You could. I'm not going to sing, though, you guys. I'm not going to sing. I mean, I could, but I'm not. That's how he learns to play songs. He doesn't know how to read music. Nanar, I didn't realize you got struck for that. Yeah. I mean, it was, I just posted it on, I have a family channel, and I posted it there. So people could, people in the family could go and see it. Family and friends. I didn't care. I mean, it's just for my family. We didn't care. But Sinbad, how does my daughter do cover songs on her YouTube channel? She doesn't care about monetization, though. Well, that's probably why. If you don't care about monetization, then you can do all you want. Do I need a break? Yeah, maybe. I'll take a break when I'm dead. Fala sometimes makes me want to throw his phone in the toilet. Yeah. You guys all think that I have a good voice. I don't. I really don't. I have always worked with a singer. I'm not a singer by any stretch of the imagination. So I don't want to. I'll sing here and there, but I'm just not going to right now. I'm not going to bust out into song for you guys. Sorry. Mo Freedom. Will I get copyright strikes for recording Super Bowl snoring? That would be catastrophic. The only person that would copyright strike you would be Super Bowl. All right, so let's see. Let me think for a second. Monica's going to start in 20 minutes. So, yeah, maybe I will take a break. The shirt reminds me I need to sew a shirt for my husband. I've had the fabric for eons now. Yeah, I got this shirt a long time ago. It's really soft. It might be like rayon or something. I'm not sure, but it's soft. I got this, I think, in New York. That's how old this is. This is probably like 25 years old or something. Yes, Super Bowl is very litigious. Ken and therapist, Now that is the last thing you're going to see me do, Dreama. Dual streams on camera 24 hours a day, and we still want more. I know. Chat is never satisfied. You guys, I love doing what I do. Trust me, I don't mind. And when I need a break, I take a break. I'm just looking forward to not having to get up at 5:30, 6 o'clock every morning, because, we're up until like midnight with Joe, and then getting up at 5:30, 6 o'clock, and then streaming. It's Monica. Once Monica is over, then I'll kind of have a little bit of a shift. But Erin, unfortunately, she has the marketing company. She's still going to be getting up at like 6:30 or 7. Only if you come on and sing it with me. How about that? I'll play it, you sing it. Is that a deal? You know where to put it, Rachel. You know where to put it. I'll play it, you sing it. If we have a deal, but you have to sing it as either Lori Daybell or Sarah Boone. How about that? How rude of YouTube to strike you when your sister and brother-in-law were on? Well, it is what it is. All right, Lily Wayne, go unload those groceries. Dreamer says, we love it, what you and Aaron do for us. Well, thank you. Widespread panic. I do hope I'm able to sleep in tomorrow. Curvio, yeah, the system is so stupid and sucks so bad. Feel bad for you. It is what it is. You know, you work within the system, right? Ken says, you mean the man who, I can't even read that word right now, negligently installed a defective cat bed, causing it to fall with resulting lifelong actual and special damages to Super Bowl? It's all about how you frame it. With AI, we all have great voices. That's true. Sinbad, it'll all work out after Monica Semenlinski is, yep. Orange pants. Time for the orange pantsuit. That is true. Time for the orange pantsuit. I did. I caused irreparable damage, lifelong damage to poor Super Bowl. She's literally like right here. All right. She's like, wait. She's like right there. I can't tip because it's a Mac, right? So it's on the computer, so I can't tip it all the way down. But she's literally like right here. She's sleeping comfortably. Yes, the orange pantsuit. I think that was Sarah Boone. Did we come up, or was it? Where did the orange pantsuit come up with? Maybe Louisma. Might have been Louisma. We came up right around that time, and Chloe Driver. I think that's when we came up with the orange pantsuits. Super Bowl seems really distraught over it. Ken says, considering she was in the bed the next day. She was in the bed as soon as I put it back on properly, like within minutes. It fell. I put it on properly. She didn't sue me, thank God. As litigious as she is, she didn't sue me. Yes, the orange pantsuits. The orange pantsuit. Getting modified for the, getting outfitted for, Monica is getting outfitted for the, okay, I put yours, I'm assuming you said you meant song, but I put your song in mod chat, so start practicing. Rachel, you are so demanding. Do you have a key for me? Or what key is your best key? What key do you sing in? The key of evil? We'll do it in the key of evil. Pammy, sandwich time. I'll be back in a few. All right. Enjoy, Pammy. Go sneak out on your Black Betty for a half an hour. Pammy in her leather. I was wearing my leather. And this cop came up to me and I was like, yeah, whatever. Sinbad, poor Super Bowl. She doesn't look all that damaged. She's not. Maybe emotionally, mentally. She bounced back pretty quickly. All right, you guys, I am going to take a break. We're going to be here. You're the one who told me where to put it. Yes, the monotone key. 88 key. Super Bowl is perfect. Even her snores are adorable. Bambi, ooh, great idea. All right, I'm going to take a little break. We're going to stay here. We're staying here. We're not going anywhere. So, and I have to stay close by. Usually I take a little walk around the yard, but I have to stay close by. So, emotional damage, yes. I will, Irish Amy, thank you. Super Bowl is stoic and tough. She'll never show the pain. That's right. All right, guys. We're going to stay here, but we're also going to be on Lori Daybell in like 15 minutes or so. So I will be here. All right, sorry guys, that was my bad. False alarm. That's my bad over here on Monica's. That was seems like a false alarm. The cameraman was moving all kinds of stuff. Put out the false alarm, I know. Oh God, my head's gonna explode. I got epic cross exam over here on Lori and possible verdict coming in on Monica. All right. Seems like a false alarm.
And alternatives are not present. I received the following communication from the jury. They want the recording of Austin's Perkins conversation, if possible. At that time, I sent back the note for clarification by the jury, and then they said, we'd like the recordings and or the transcript, but the recording is preferred. As I understand it, there is no recording or transcript that is in evidence. Is that correct?
Correct.
Yes. And that's my answer to the jury. We can have the jury and alternates, please.
Would you buzz in the jury and go get the alternates?
You want to say there was testimony?
I do not add to questions. I answer them.
Right, they wanted a transcript of the recording, it sounds like. Let me rewind that.
Recording or transcript clarification by the jury, and then they said, communication from the jury. They want the jury and also now joined us. Good afternoon. Jury number 10, you are the foreperson, is that correct?
Yes.
I received the following communication from you and the jury that you wish the recording of Austin's Perkins conversation, if possible, at which time I sent the note back for clarification. We'd like the recordings and or the transcript, but the recording is preferred. The recording of the Perkins operation of Austin and any transcript was never received in evidence. That should answer the jury's question. It's now 4 o'clock. I'm going to let you go. The admission applies still now. And you'll return tomorrow. I understand because of rehab, you're coming back at 10 o'clock. Is that correct? Okay. Have a good evening.
All right, so they wanted the recording from the Austin Perkins. No, they wanted the transcript from the Austin Perkins, and then they're going to come back at 10 o'clock tomorrow. So that's going to be 1 o'clock our time. All right, guys. Perkins, which neither transcript nor recording was put into evidence. Yeah, so, all right. All right, I'm going to, hold on, let me take notes. So let's see, 7 o'clock they go. Even though the verdict clock is saying 4:08, which is weird. All right, guys, I'm going to end the stream here. Thanks for joining us. Appreciate you guys. Join us over at Lori Vallow. Have a good night.